You walk into the consulate at 7 in the morning. The building looks the same as it did when you scheduled your appointment 3 months ago. Security waves you through the metal detector. You hold your passport. Your documents are organized in the folder exactly how the embassy website instructed. You paid the interview fee. You took time off work. You traveled across the country or maybe across your home country to be here. The waiting room is full. Families sit quietly. Some people are reviewing their papers. Others are staring at the wall. The air conditioning hums. A digital screen flashes numbers. Then your number appears. You stand up. You walk to window 12. The officer smiles. She asks you standard questions. Where will you stay? What is your job? How long do you plan to visit? You answer clearly. You hand over every requested document. The interview lasts 11 minutes. At the end, she says thank you and tells you your application is under administrative processing. She does not say anything is wrong. She does not say you failed. She tells you to check the online portal in 2 weeks. You leave feeling cautiously hopeful. You did everything correctly. But your visa will never be approved. Not because you made a mistake, not because you are unqualified, not because the officer rejected you. Your visa will not be approved because right now in 2026, there is an invisible freeze happening across multiple visa categories and almost no one outside the immigration system knows it exists yet. Officers are still conducting interviews. Applicants are still spending thousands of dollars on fees, medical exams, translations, and travel. The system appears to be functioning normally. But behind the scenes, approvals have stopped. Applications are being marked as pending indefinitely, and if you do not understand what is happening right now, you will waste months or even years stuck in a bureaucratic trap that has no clear exit. This is not a conspiracy theory. This is not speculation. This is a documented administrative freeze that immigration attorneys are witnessing in real time, and most visa applicants will not find out about it until it is too late to protect themselves. What you are about to learn in the next few minutes could save you from losing your job offer, missing your family reunion, or destroying your immigration timeline completely. The difference between those who survive this freeze and those who lose everything comes down to whether you know the system well enough to recognize the trap before you fall into it. Here is what is actually happening. The freeze is not a law. It is not an executive order. It is not a policy published on the State Department website. It is an administrative action implemented quietly through internal directives sent to consular officers and USCIS adjudicators. These directives tell officers to continue processing applications, continue conducting interviews, continue collecting fees, but to stop issuing final approvals. Instead, officers are instructed to place applications into administrative processing or additional review status indefinitely. On paper, your case is still active. In reality, it is frozen. The government is not canceling your application. They are suspending it without gausu ni, and this is the part that makes it so dangerous. If your case were denied, you would have options. You could appeal. You could reapply. You could request reconsideration. But when your case is placed in administrative processing, there is no appeals process. There is no deadline for the government to finish reviewing your file. There is no requirement that they tell you what they are reviewing or when they will make a decision. You are simply told to wait. Most applicants do not realize this is a freeze. They think their case is being individually reviewed. They believe that if they wait patiently, the process will continue moving forward. They check the online portal every few days. They send polite follow-up emails to the consulate. They wait for the 2 weeks to pass, then 4 weeks, then 8 weeks. Then 6 months, and nothing changes. Some people assume their case has a problem and they spend money hiring attorneys to investigate. Others believe they need to submit additional evidence, so they gather more documents and mail them to the embassy. A few applicants assume the delay is normal because government processing is slow. All of these people are responding to the freeze as if it were a standard delay. But it is not a delay. It is a hold. And responding to a hold with standard strategies wastes time, money, and in some cases makes your situation worse. Here is the first trap. Many applicants believe that continuing to engage with the system will help their case move forward. So they respond to every request for additional information. They attend secondary interviews if asked. They submit updated financial documents. They provide new employer letters. They comply with every instruction from the consulate. And in normal circumstances, this would be the correct strategy. But during a freeze, these actions do not move your case forward. They create more documentation in your file that can later be used against you if policies change or if enforcement priorities shift. Every piece of information you provide during this freeze is being collected and stored but not used to make an approval decision. You are essentially giving the government more leverage over your case while receiving nothing in return. The second trap is financial. Visa applicants are continuing to pay non-refundable fees for services they will never receive. Interview fees are not refunded if your case is frozen. Medical exam fees expire after 6 months, so applicants in administrative processing often have to pay for a second exam if the freeze lasts long enough. Applicants who are working with immigration attorneys continue paying hourly rates for follow-up work that produces no results. And perhaps most damaging, applicants who are already in the United States on temporary status continue renewing their current visas or work permits because they believe their immigrant visa or green card application is about to be approved. They spend thousands of dollars maintaining legal status while waiting for an approval that is not coming. This financial trap is particularly cruel because it punishes people for doing exactly what they are supposed to do, which is stay in legal status and comply with immigration rules. The third trap is opportunity cost. Applicants who are frozen in administrative processing often turn down other immigration pathways because they believe their current application is nearly complete. A worker on an H-1B visa might refuse a job transfer to a different country because they think their green card is 2 months away. A student might decline admission to a graduate program because they expect their visa interview to result in approval soon. A family member might not explore alternative visa categories because their current petition is pending. These decisions make sense if you believe the system is functioning normally. But if you are stuck in a freeze, these decisions lock you into a pathway that is not moving while other options pass by. Now let me explain why this freeze is happening and why it is structured this way. Administrative freezes are used when a government wants to slow or stop immigration without officially changing the law. If the administration announced a formal ban on certain visa categories, there would be immediate legal challenges. Advocacy groups would file lawsuits. Congress might intervene. The media would report on it. But an administrative freeze avoids all of that. The law has not changed. The eligibility requirements have not changed. The application process has not changed. All the administration has done is quietly instruct officers to stop making approval decisions. This allows the government to achieve the same result as a ban without the political or legal consequences of implementing an actual ban. The freeze is also designed to create confusion and compliance fatigue. When applicants do not know whether they are denied, delayed, or frozen, they do not know how to respond. Some give up and withdraw their applications. Others wait indefinitely. A few file expensive mandamus lawsuits to try to force the government to make a decision. But none of these responses challenge the freeze itself because the freeze is not an official policy that can be challenged. It is an internal directive that does not appear in any public regulation or court-reviewable document. This makes the freeze legally invisible, even though its effects are very real. You need to understand how administrative processing actually works so you can recognize when you are trapped in a freeze versus a legitimate delay. Normal administrative processing happens when a consular officer needs additional time to verify your background, check security databases, or request clarification on specific parts of your application. In these situations, the processing has a clear reason. The officer might tell you they are waiting for a specific clearance from a government agency, or they might request a particular document from you and explain why it is needed. Legitimate administrative processing usually resolves within 60 to 120 days, and most importantly, during legitimate processing, your case is actually being worked on. Databases are being checked. Your information is being reviewed by security analysts. Your case is in a queue. But during a freeze, none of that is happening. Your case is not being reviewed by anyone. No databases are being checked. No security analysts are working on your file. Your application is simply sitting in a digital holding status waiting for the internal directive to be lifted. The government is not processing your case administratively. They are freezing it administratively, and the only way to tell the difference is by recognizing the patterns. Here is what the freeze looks like in practice. If you request a status update from the consulate, you receive a template response that says your case is still under administrative processing and no timeline is available. If you ask what additional information is needed, you are told that no additional information is required at this time. If you submit new documents anyway, the consulate acknowledges receipt, but your case status does not change. If you contact your congressional representative, their office sends an inquiry to the consulate and receives the same template response. If you hire an attorney to file a Freedom of Information Act request, the documents you receive show that your case was flagged for administrative processing but contain no explanation of what is being processed or why. All of these responses are designed to make you believe your case is moving through the system when in reality it is frozen. Now here is the critical question. What do you do if you are already trapped in this freeze, or if your interview is scheduled in the coming weeks? The answer depends on your specific situation, but there is a defensive strategy that applies to almost everyone. This strategy will not get your visa approved during the freeze, but it will protect you from making the situation worse, and it will position you to respond quickly if the freeze is lifted or challenged in court. Step 1. Do not provide additional information unless it is legally required. If the consulate sends you a formal request for a specific document, and that request includes a deadline, you must comply. But do not volunteer extra documents, updated letters, or new evidence in an attempt to move your case forward. Every additional piece of information you provide during a freeze creates more material in your file that could be scrutinized under different standards if policies change. Limit your interaction with the system to what is absolutely required. Step 2. Document everything in writing. Keep copies of every email you send to the consulate and every response you receive. Take screenshots of your online case status showing the date it was marked as administrative processing. If you attend an interview, record the date, time, window number, and a summary of what the officer told you immediately afterward while the details are fresh. If the freeze becomes the subject of a lawsuit or policy change, these records will be critical evidence showing when your case was frozen and what you were told. Step 3. Maintain your current legal status if you are already in the United States, but do not make long-term commitments based on the assumption that your frozen case will be approved. If you are on an H-1B visa, continue renewing it. If you are on a student visa, stay enrolled. But do not turn down job opportunities, reject graduate school offers, or make irreversible life decisions while your case is frozen. The freeze could last 6 months or it could last 3 years. You cannot afford to put your entire life on hold indefinitely. Step 4. Explore alternative visa pathways immediately. If you are waiting for a family-based green card, research whether you qualify for an employment-based category. If you are waiting for an employment visa, investigate whether you are eligible for a different work authorization. If you are waiting for a visitor visa, consider whether a student visa or exchange visa might serve your purpose. Do not assume that starting a new application will hurt your frozen case. You are allowed to have multiple pending applications in different categories. And if one pathway is frozen, having a second option active protects you from being completely stuck. Step 5. Monitor the situation through reliable legal sources. Follow immigration attorneys who specialize in consular processing and visa issues. Join online communities where applicants in administrative processing share updates. Check the websites of major immigration advocacy organizations for announcements about systemic processing delays. Do not rely on unofficial rumors or unverified claims, but do stay informed about patterns that could indicate the freeze is expanding or being challenged. Step 6. If the freeze lasts more than 6 months, consult with an immigration attorney about whether a mandamus lawsuit is appropriate for your situation. A writ of mandamus is a legal action that asks a federal court to order the government to make a decision on your case. Mandamus lawsuits do not guarantee approval, but they can sometimes force the government to move a case out of indefinite processing. These lawsuits are expensive, and they do not work in every situation. But if you are facing serious harm from the delay, such as losing a job offer, missing a critical family event, or aging out of eligibility, then mandamus may be your only option for forcing action. Step 7. If your interview has not happened yet, Do not cancel it, but prepare yourself mentally for the likelihood that you will receive no approval on the day of your interview. Attend the interview. Answer all questions honestly. Submit all required documents, but do not expect a decision. Do not make travel plans based on the assumption that you will have your visa within 2 weeks. And do not spend additional money on services or arrangements that assume your visa will be issued soon. Treat the interview as the first step in a potentially long process rather than the final step. This freeze is happening now, but it will not be the last time the immigration system uses administrative holds to control the flow of approvals without changing the law. Over the next few years, you will see more freezes affecting different visa categories, more indefinite processing delays, and more situations where the system appears to be functioning but is actually paralyzed. The government has learned that administrative actions are harder to challenge in court than official policy changes. They are faster to implement and easier to reverse if political pressure builds. This means that even if the current freeze is lifted, you should expect similar tactics to be used again in the future. You should also expect increased biometric tracking and data collection to continue during freezes. Even when approvals are stopped, the government is still collecting fingerprints, photographs, social media account information, and travel history from every applicant who goes through the interview process. This data is being stored in databases that will remain active for decades. If you attend a visa interview during a freeze, your information will be recorded and accessible to immigration enforcement agencies, even if you never receive the visa you applied for. This is another reason why limiting the amount of voluntary information you provide is critical. The system is designed to collect maximum data while providing minimum approvals. There is one more thing you need to understand about this freeze. Knowing that it exists does not make you powerless. It makes you informed. Most people who are trapped in administrative processing right now do not understand that they are caught in a system-wide hold. They think their individual case has a problem. They blame themselves. They wonder what they did wrong. They waste months trying to fix an issue that does not exist in their file. But you now know the truth. You know that this is not about you. It is about a policy decision made at the highest levels of government to stop processing certain applications without admitting that publicly. And once you understand that you can make better decisions, you can stop wasting money on strategies that do not work during a freeze. You can avoid giving the government more information than legally required. You can protect yourself from opportunity costs by exploring alternatives. You can recognize the patterns that indicate whether your case is legitimately delayed or systemically frozen. And perhaps most importantly, you can help others. Your family members, your friends, your coworkers, and your community members may be walking into this same trap without realizing it. They may be scheduling interviews, paying fees, and making life decisions based on the belief that the system is working normally. They need to know what you know now. Share this information. Explain to people in your community that attending an interview does not guarantee an approval timeline. Warn them that administrative processing during a freeze is different from normal processing delays. Tell them to document everything, limit voluntary submissions, and maintain alternative options. This knowledge is protective. It does not make you suspicious. It does not make you guilty of anything. It makes you prepared. And preparation is the only defense you have when the system itself is frozen. Subscribe to this channel so you stay informed about every immigration freeze, policy shift, enforcement update, and legal trap that could affect your status. The rules are changing faster than ever, and the only way to protect yourself is to know what is happening before it is too late. The next video could be the one that saves your case.